Hello, my name is Milo Booth, and I'm the Director of Tribal Affairs in the Office of Secretary at the Department of Transportation. In addition to the Tribal Transportation Self-Governance Program, I also oversee all tribal interaction on behalf of the Secretary, such as tribal consultations, meeting requests and engagements, tribal IGA efforts, and so forth. We are very excited about this new and historic program at the Department, and we have been receiving a great deal of interest in the program from tribes and tribal organizations throughout the country. So I'm very pleased to share some information about this new program with you, and I hope you will find this information enlightening. The purpose of this new program is to provide Indian tribes and tribal organizations with greater autonomy, control, flexibility, and decision-making authority over transportation funds used to carry out tribal transportation programs and activities in Indian country. By way of background, the Tribal Transportation Self-Governance Program, or TTSGP as it's known, was authorized by Section 1121 of the FAST Act. This provision is now codified in U.S. Code at Title 23, Section 207. To develop the Tribal Self-Governance Regulation, the FAST Act directed the Department to engage in a negotiated rulemaking with federally recognized Indian tribes in accordance with the Negotiated Rulemaking Act. Through a government-to-government relationship, the Rulemaking Committee produced a negotiated transportation rule that effectively advances the federal government's policy of self-determination and self-government for Indian tribes. The final Tribal Self-Governance Regulation was published in the Federal Register on June 1, 2020, and the new rule became effective on October 1, 2020. The Tribal Self-Governance Rule is codified in the Department of Transportation's regulations at 49 CFR Part 29. With this new Tribal Self-Governance Program, the Department joins the Departments of Interior and Health and Human Services, respectively, which for many years have already implemented tribal self-governance programs. I would like to note this is a voluntary program, so if a tribe wants to continue under a Federal Highways Transportation Programmatic Agreement or an FTA Tribal Transit Program Grant Agreement or any other department funding agreement, a tribe is free to do so. Nothing will change. But if they want to participate in the department's TTSGP, they may start the process by submitting a written request to the department's self-governance official that it intends to participate in the program. We don't have an actual or an official application form, so a tribe would begin this process by sending us a letter demonstrating that they want to enroll in the program and also that they will meet the eligibility requirements to do so, of which there are 3 statutory eligibility requirements. 1, a tribe must have financial stability. 2, they must have financial management capability. And 3, they must have a transportation program management capability. The financial stability and financial management capability requirements will together be evaluated based on the Department's review of a tribe's audits under the Single Audit Act or independent audits for the previous 3 years. Regarding the 3rd eligibility requirement of transportation program management capability, this will be a discretionary determination by the Department. To meet this requirement, a tribe should provide evidence to demonstrate experience in the planning, design, operation, or management of a transportation system or project. Even if these activities were not federally funded, the Department will then evaluate the totality of evidence on a case-by-case basis to determine whether the evidence submitted is enough to meet this particular requirement. After a tribe submits a request to participate in the TTSGP, along with supporting documentation to demonstrate that it meets the 3 eligibility requirements, the Department will then review the evidence submitted and notify the tribe within 120 days regarding its eligibility to participate in the program. I will also point out that the Tribal Self-Governance Program is prospective in nature, so it won't change or affect any existing federal funding agreements between the Department and a tribe or between a state government and a tribe. The provisions of the TTSGP will only apply to new federal transportation funds that are provided to a tribe through a negotiated compact and funding agreement under this program. Once a tribe has been notified by the Department that it is eligible to participate in the Tribal Self-Governance Program, a tribe may then request the Department to enter into negotiations for a compact and funding agreement. After receiving this request, the Department and tribal representatives will then engage in one-to-one meetings to negotiate the terms and conditions of a compact and a funding agreement. The compact will affirm the government-to-government relationship between the Department and a tribe. It will also set out the general terms that govern a tribe's participation in the TTSGP and such other terms that the Department and tribe mutually agree will continue to apply from year to year. A tribe must have a compact in place to participate in this program. The duration of a compact is perpetual unless terminated by mutual written agreement, or under the provisions of the Tribal Self-Governance Regulation. The funding agreement in the Tribal Self-Governance Program is the legally binding written agreement that identifies the funds a tribe will use to carry out its programs and activities. It will set forth the terms and conditions under which the tribe will receive the funds. The duration of a funding agreement will typically be for 1 year, but the regulation does allow for multi-year funding agreements. Once a tribe makes a request to enter negotiations for a compact and funding agreement, the rule provides for a 90-day time period to complete the negotiations, although, if necessary, the 90-day time period can be extended by agreement. When negotiating compacts and annual funding agreements, a tribe and the department may find they cannot agree on a proposed term in a compact or funding agreement. On such occasions, if they're unable to successfully reach mutual agreement on a disputed term, the regulation establishes a formal process where a tribe can make a final offer on a disputed term to the department. To initiate the formal final offer process under the regulation, a tribe may submit a written final offer to the department's self-governance official. The final offer must contain a description of the disputed term or terms and a tribe's final proposal to resolve the disagreement. The department will then have 45 calendar days to accept or deny the final offer. If the department fails to respond to the final offer within the 45 days, the final offer will be deemed accepted by operation of law. The department can reject a final offer for any of the following 4 reasons. 1, the amount of funds in the final offer exceeds the amount to which a tribe is entitled. 2, the subject of the final offer is an inherent federal function that cannot be legally delegated to a tribe. 3, carrying out the program or activity would result in significant danger or risk to public health or safety. Or 4, a tribe is not eligible to participate in the self-governance program. Finally, a tribe has the right to appeal the department's rejection of a final offer directly to federal court. Alternatively, a tribe may choose to exhaust its administrative remedies within the department. So this will complete my discussion on the eligibility, negotiation, and final offer processes in the program. To discuss the funding and administrative requirements associated with the Tribal Self-Governance Program and to cover the program benefits afforded to participating tribes, I will now turn it over to the Tribal Self-Governance Specialist, Eldridge Onco, who has been working with me to implement this new program. Thank you.
Thank you, Milo. My name is Eldridge Onco. The next 3 topics I want to cover are the department funds a participating tribe may use in the self-governance program, the administrative requirements of the program, and the program benefits that are available to a participating tribe. There are 6 categories of transportation funds a tribe may include in a compact and funding agreement. The first category involves department, discretionary, or competitive grant funds. So, for example, if a tribe is awarded a bill grant by the department, a tribe could include the bill grant funds in a compact and a funding agreement. The second category is funding provided to a tribe under FHWA's Tribal Transportation Program. FHWA's program provides federal assistance to tribes for the construction, repair, and maintenance of roads and bridges on Indian reservations. The third category concerns funds awarded to a tribe under FTA's Tribal Transit Program. These funds may be used for planning, operating, or capital transit projects on Indian reservations. A fourth category will be discretionary or competitive grant funds from FHWA or FTA. So, for instance, the funds in a discretionary grant awarded to a tribe in FTA's Tribal Transit Program could be used by a tribe under the terms of a compact and funding agreement. The fifth category are federal aid highway funds apportioned to a state. A state, however, would need to consent to transfer the funds to a tribe under the Section 202A9 transfer process in Title 23 of the U.S. Code. Finally, a sixth category concerns funds under FTA's Rural Area Program, which is administered by a state. If a state selects a tribe's project for award under the Rural Area Program, the state, if it agrees to do so, can transfer the funds to FTA, and these funds can be included in a compact and funding agreement. So these are the six categories of funds that may be included in a tribal self-governance compact and funding agreement. This next slide will cover how the tribal self-governance program and program funds are administered and managed. A tribe will manage the day-to-day responsibilities of the program and activities in a compact and funding agreement. By doing this, a tribe will have the ability to more quickly and more effectively respond to the transportation needs of its community. The funds will be subject to the financial management system standards in the self-governance rule to ensure that the expenditure and accounting of funds will be consistent with the terms of the compact and funding agreement, the applicable statutory requirements and applicable provisions in OMB's regulation at 2 CFR Part 200. With respect to procurements, a tribe's procurements under a funding agreement will generally be carried out in accordance with the procurement standards in 2 CFR Part 200, and to the greatest extent feasible, the tribe must apply the Indian preference requirement to any procurement award. As for record keeping, a tribe must maintain a record keeping system, and the tribe must provide the department with reasonable access to the records. In addition, a tribe must maintain a property management system to account for all property acquired with funds under a funding agreement. The provisions of OMB Super Circular at 2 CFR Part 200, including the federal cost principles, will generally apply to the tribal self-governance program, except as the provisions may have been modified by statute or OMB exemption. In addition, a participating tribe may request a waiver of the self-governance regulations. The department will have no later than 90 days after receipt of a request to approve or deny the request. If the department does not approve or deny a request within 90 days, the waiver request will be deemed approved by operation of law. I'll also point out that a consortium of 2 or more tribes may participate in the program by entering into a single compact and funding agreement on the same basis as an individual tribe. The tribal self-governance program will provide a host of benefits to a participating tribe, and most of these benefits are generally not available to tribes in other department programs. The most important benefit, of course, is that this program will support a tribe's inherent right to self-determination and a tribe's inherent right to exercise self-governance. The terms of a negotiated compact and funding agreement can serve to promote administrative streamlining for tribes by reducing or eliminating burdensome administrative requirements. Also, instead of multiple funding agreements, there will be a single funding agreement. So instead of separately administering funds under a FHWA TTP agreement and a FTA grant agreement, a tribe would only be subject to the terms of a single annual funding agreement. A tribe will also be able to receive a lump sum payment or a periodic payment of funds instead of receiving funds on a cost reimbursement basis. In addition, a tribe may invest and manage formula funds, and the tribe may also retain interest earned on funds and use the interest earned to carry out transportation or governmental functions. A tribe won't be subject to department rules, policies, manuals, circulars, or guidance unless the tribe expressly agrees to be subject to them. So a tribe's use of this benefit could effectively reduce or eliminate many administrative requirements. Also, the funds under a compact and funding agreement may be used as local match for other federal and non-federal programs. A participating tribe will have the right to administratively appeal pre-award and post-award decisions. And in some cases, the decisions can be appealed directly to a federal court. Under a funding agreement, a tribe will be able to carry out its employment and contracting preference laws, such as a tribe's employment rights ordinance. A tribe's formula funds will only be subject to statutory reporting requirements. However, for discretionary or competitive funds, the department and the tribe will negotiate the appropriate reporting requirements to include in the funding agreement. And the tribe will have access to federal supply sources such as GSA's purchasing schedules, and the tribe will be able to use federal travel resources when carrying out programs and activities in a funding agreement. When carrying out tribal programs and activities under a compact and funding agreement, the tribe and its employees will also be covered by the Federal Tort Claims Act. Finally, to the extent feasible, the department will, upon request, provide technical assistance, including periodic program reviews, to assist the tribe in improving the performance in carrying out its self-governance program. So in conclusion, I hope this overview of the tribal self-governance program has been informative. I will note that many tribes have experienced great success with the self-governance programs that have been established by other federal departments. And it is our expectation that tribes will enjoy the same, if not more, success with this new tribal self-governance program in the U.S. Department of Transportation. So I appreciate your time today. And at this time, Milo and I will be glad to respond to any questions you might have. Thank you.